All right, and I'm going to go ahead and let everybody in the waiting room and then do a little brief introduction and then we get started. Sound good?
Great.
All right, awesome. Here they come. All right. Good afternoon, everyone, and welcome to our workshop entitled How to Be a Trustee Without Losing Your Hair or Starting a Family Fight. We are so happy that you've decided to join us today, and we can't wait to provide you with this exclusive information and some resources that will give you a deeper understanding of us and our services. I would like to invite you all to type any questions that you may have in the chat box that's located at the bottom of your screen throughout the entire presentation. And then at the end of the hour, Adam and I will address any of those questions or concerns that you may have. So without any further ado, I'm just going to go ahead and hand it over to one of our attorneys, Mr. Adam Dees, to go ahead and get us started today.
Hey, Emily, thanks for the introduction. I am really excited about the topic we're going to be talking about today. It's about how to be a trustee without losing your hair or starting a family fight. I do have some slides that I would like to share with you. And so hopefully that is working out. So today, just to jump right in, you'll discover how to maintain family relationships, how to be transparent, how to protect your family from dishonest creditors, ways to limit or eliminate taxes and estate recovery if you've worked with Medicaid, and simple and legal ways to transfer resources from one generation to the other. And I find that this is a very important topic, especially if you are a trustee, if you might be a trustee in the future, if you're thinking about setting up a trust for yourself or your family so you can know what they can expect if something were to happen to you, if you're worried about taxes, if you're worried about preserving a legacy, if you're concerned about Medicaid, estate recovery, long-term care costs, or if you have a family business or a farm. And I'll be honest with you, this is a very, very basic discussion of the duties of a trustee and the steps that they need to take. And so this is really not for people who are looking for like a continuing legal education type of thing. It's more about a general 10,000 foot overview. And it's really also not for people if your family is planning on not having a plan in place, not to do anything, and letting the government decide what to do with your family's property. If your family is planning to go through probate, if you don't know what's important about being a trustee, and if you as a trustee just want to ignore your responsibilities, obligations, and how to be a good trustee, this is not for you. And really, you could probably just sign off right now or here in a bit if this is too basic, or if again, you know your family's not going to have some type of plan in place. Trust administration is for you if you don't want to have court involvement, if you want something customized, want privacy, and are ready to pre-plan, because everything we're going to talk about today requires a family to pre-plan what happens when someone passes away. And if you want flexibility, this plan is for you. If we have to go through a probate or a guardianship or conservatorship, and we'll talk about what those are here in a bit, those aren't nearly as flexible as doing trust. So let's imagine that you could wave a magic wand and know that you've followed your family's wishes, know that you've protected your family's legacies, know that you're not going to lose property because of government taxes or long-term care costs or estate recovery, and that you have peace of mind knowing that everything is complete and correct, not only during your lifetime, but also as you pass those resources on to your children. And so this really started out with a client of mine, JC. He had family spread across Kansas. He had lots of real property all over the place. He felt like he was in the middle of his siblings and that it was hard to do a bunch of communication with them. And so he wanted all of the communication to come through cling scales through our office and to guide him through that process. And it was through that process of guiding him that I really developed this presentation and this discussion. And he says that he highly recommends cling scales elder law practice. He said that we made him feel like things were done right, they were done on time, and they made him feel comfortable and at ease. So he didn't have to worry knowing that his parents' wishes were respected and that his siblings and the other people that he was working for were also respected, and that he fulfilled his duties to those folks. So who am I? I'm an attorney. We have offices in Hayes and Wichita, and we literally have clients throughout the state of Kansas, Tribune, Kansas, all the way up to the Kansas City metro area. I'm a certified elder law attorney by the National Elder Law Foundation and the American Bar Association. And my goal is to preserve and promote family harmony and preserve and pass on family legacies. I've been an attorney for about 10 years. Actually, it's been 10 years now. I was a general practitioner for 5 of those years. And then the last 5 years, I've really focused my practice on working with elder law and the transition of resources from one generation to the next. And I can tell you that these last 5 years have been the best. So a little bit more about me. This is my family. My wife is Alyssa. She's a 3rd grade teacher. Christina is now 15. I think she's going on 21. And my daughter, Rachel, is 9. And then we have 2 dogs, Simon, who's our Cavalier King Charles Spaniel, and Bridget, who is our professional mutt that we accidentally adopted last year. So why do I really love this? And really, I was inspired by my grandfather. You can imagine, his name was Alan Pullen. And about this time of year, he would don a red suit and a red cap, and he would go out and he would be Santa Claus. And about 5 years ago, my grandmother called me and said that he has Parkinson's disease. And she wanted to know how to work through that process. And I, at that point, was a general practicing attorney in Kansas and didn't feel like I had the tools necessary to help her with his Parkinson's and working through that disease progression. And I got fortunate. Cling Scales Elder Law was looking for an attorney to join their team. And that's when I joined their team to help my grandmother and my grandfather. And then upon my grandfather's passing, my grandmother asked me, so, what are the steps now that he's passed that I need to take? And I was able to walk with her through that. So to make that easy on her. And for her, we spent about 4 hours doing it because we had pre-planned and had everything in place. So the lessons that they really taught to me was that family was first. And my grandfather, who was a pastor in the United Methodist Church since the age of 16, really told me that everybody grieves in their own way. And death does interesting things to people, but that through transparency and openness, we can keep those relationships that we had before someone's passing. And last, I think the most important thing is having a plan and having a guide works, having someone to talk with through that process as you're going through the emotional, financial, mental, spiritual process of losing a loved one. Having a plan and a guide helps make that go easier. So again, this presentation is inspired by my clients. Kevin, we're going to call him Kevin. This was Kevin a few years ago, and this is just a fun picture. But he came to me about a year ago, and this is what he looked like. He had lost all of his hair. He was very worried. He was very he was frowning. He looked like the weight of the world was on his shoulders because he had just lost his sister and didn't know what to do. And so my job is to try and bring the Kevins that work with us back to a place of peace, a place of comfort, and a place of relaxation. And so what Kevin had to say once we went through our process was, you did everything we asked and more, My experience was wonderful. You gave me peace of mind, which helped the whole family through this difficult time. Thank you for all you do. So, what do you need to know? You need to know that your family can have a smooth transition that protects your family's legacy and maintains your family's relationships. And so we're going to talk about how that works. So you're going to discover the importance of keeping the beneficiaries, the people who are going to receive resources upon someone's death, informed about what's going on. We're going to talk about some hidden dangers when dealing with the IRS, with the state recovery, and with Medicaid, and everything that you absolutely know about the right time, because timing is very important to this process to distribute resources to those beneficiaries. So to start off, why is it so important to keep beneficiaries informed of what's going on? Well, the first is because the state of Kansas requires it. In fact, the state of Kansas says that at the end of the process, the state wants you to provide certain information as a trustee to the beneficiaries of the trust. And doing that can limit the number of questions that you get during that process, but it also speeds up the process, because with the information that you provide to beneficiaries, then they're comfortable with the actions that you take as a trustee. And so it makes things easier. So there was one family, this is the estate of Nelson. This is a case out of Northwest Kansas. And he was actually the executor of his brother's estate. And he kept records on scraps of paper, on napkins, on envelopes. And it came time in the middle of a probate. So this is not trust administration. This is a probate. We have a court involved, and we're all trying to avoid that. But Mr. Nelson didn't pre-plan, so we were in court. The court found that based on the lack of record keeping, that Mr. Nelson needed to pay the estate and the beneficiaries about $9,000 because he could not account for the resources, and he could not tell the beneficiaries, and he could not tell the court where those resources went to. And so it's very important to keep beneficiaries informed and to keep an accurate accounting of what resources are received, what money comes into the estate or the trust, and what money is spent. And just to quote the statute, KSA 58A 813 says that the trustee has a duty to keep beneficiaries reasonably informed. Now, what we like to see is that there's been some kind of contact with the people that are going to receive resources after someone's death about every 30 to 45 days. And that seems to be about the time that beneficiaries start to call and wonder, okay, is anything going on? And really, it can be something as simple as a 1 or 2 word email that says, hey, there's nothing new. We're waiting on this institution to get us this information. We're waiting on a notification period to pass, which we'll talk about later. We're just waiting on something. I just want to let you know that we're thinking about it and we're working on these things. And that seems to make everything go smoother. The beneficiaries feel more involved in the process. They feel like they know what's going on. Maybe a little bit more work for you as the trustee, but if it can prevent something like $9,000 needing to be paid into the estate or some other type of court action, I think a little bit of an email is certainly worth the time and effort. There's a duty also to respond to requests for information. So if a beneficiary asks for information, then hey, there needs to be a response. Now, it doesn't have to be immediate. You can take some time. You can think about that response. And yet the idea is we want trustees and beneficiaries to be in communication with each other. There's a duty to provide a copy of the trust. And depending on the type of trust, the duty to provide reports that talk about the financials from year to year, and the financials specifically of when you as trustee make payments to the beneficiaries. So again, everybody can see what's going on, and nobody's surprised by things. So what do we do? Let the beneficiaries know you're trustee. Send them a copy of the trust. Provide them periodic updates and information, even if nothing is going on. Provide the beneficiaries an inventory. So that's a list of all the trust resources. and what's going to be paid out. And again, I can't emphasize this more. I don't think I've gotten a phone call or an email from a beneficiary saying, hey, you've given me too much information. Stop it. Stop sending me stuff. I'm tired of getting all of this stuff. I don't think any beneficiary of a trust has ever said that. And then, of course, have a trusted guide to help you. Have someone who has a system in place and has a process in place. Because most people go through this process maybe once, twice, maybe a family will go through it 4 times in their lifetime if they have a couple of parents. And yet there are trusted professionals who do this every day, every year, all the time. And so having a trusted guide, I think, is really, really important. Again, what's the benefit to this? It limits questions and it speeds up the process. And anticipating questions and being proactive, again, limits the request for information. It builds trust with the beneficiaries, so there are few questions at the ends. And it may even encourage beneficiaries to waste some time limits. Again, we'll talk about those time limits here in the next half hour or so. The other thing is that there are hidden dangers out there if we don't follow the process. Okay, and those can come from creditors, those can come from the IRS, and those can come from estate recovery or Medicaid. So one of the biggest dangers is not knowing what we don't know. And we're going to talk about a case here in a minute that highlights making sure you follow the process because you may not know what you don't know. Not filing the right tax returns and rushing when dealing with estate recovery or Medicaid liens. So first, the hidden dangers of creditors. This was one of the first cases I worked on as an attorney. And this is the estate of Solzman. It's a Court of Appeals case in the state of Kansas. And Frank Solzman had an alleged child that was completely unknown to the family. So I represented the executor of Frank's estate. And in that estate, they opened the estate. They kept all the beneficiaries informed. They closed the estate and paid out the resources of Frank's estate, which is about an $8 million estate. And 2 years after that estate was closed, the alleged illegitimate child asked to reopen the estate, asked to come back in, and asked to take the $8 million that was in that estate back all for herself. Now, that was after, excuse me, that was after parts of that estate had been given to other people because of the passing of some of the people that received part of that estate. There had been a corporation that had set up and was in business for a couple of years. And the child, the alleged child that we did not know about, that the executor did not know about, was asking that all of that be undone and the funds go to her. But the state of Kansas provides that you can put notice in the newspapers. If you see those notices in the newspaper, this is what that's for. And creditors have 4 months from the first notice to make a claim. So she had arguably 4 months to make a claim. And if it's a known creditor, you have to specifically send a letter to that creditor. And that creditor then has 30 days to respond. And basically what that creditor has to do to respond is just wave their hand and say, hey, I was a creditor of this person that passed away. I want to be paid. You, or who are working through the estate and the resources this person had, you need to pay me. Let's see. And then the other piece of that is sometimes the creditors kind of get antsy and want to be paid, but we need to make sure that those creditors get paid in a certain order because the state of Kansas says that you have to pay creditors in a certain order. The first, you have to pay the appropriate and reasonable funeral expenses. And the reason is we want people to have a proper burial in the state of Kansas. Second, Medicaid or estate recovery, which we'll talk about. And that's if someone has been on Medicaid or received from funds from the state to help pay for long-term care, they get paid second. Okay, again, because we want people to be taken care of as they get to the end of their lives. The third, and I actually didn't put this up here, the third is the cost of administration. And then the fourth is actually the IRS. So if there's an IRS lien, that person, IRS needs to get paid after the cost of administration, after Medicaid or state recovery, but before costs of administration. So funeral directors, Medicaid, IRS, costs of administration, then court judgments, then everything else. And then only after we get all those creditors taken care of are the beneficiaries, the people that the person that died wanted the resources to go to, they must be paid. But we have to get through that 4-month creditor waiting period to make sure we've gotten the appropriate notice so that nobody can come back after the fact and raise their hand and say, hey, I want all of this paid to me, because we may not have known that they are out there. So a couple of hidden dangers, though, when it comes specifically to the IRS. You do need to know that as a trustee, you will need to file a final tax return for the settlor or for the person that died. You're probably going to need to file at least one tax return for the trust. And the other danger is not getting an appraisal of real property. And this is really important. See, with real property, most of the real property we work through was purchased at a much lower value than it's currently at. And upon someone's death, the IRS is going to readjust the value of that property. They call it the basis. They're going to readjust the basis of that property to the date of the person's death. So if someone bought, say, farm ground at $50,000, and upon their death, that farm ground was worth $200,000, the IRS is going to say, hey, that property is now worth $200,000. And if the beneficiaries, the people that receive that property after that person's death, if they, don't get an appraisal and don't get that step up in basis, then they may have to pay additional capital gains taxes on that $150 of increase during the person that died during their lifetime. So it's very important, again, to make sure that the tax returns are filed, but also establish what the value of that real property is. At this point, there are some people that I'm working with, and we are going back to the, trying to go back to the 1950s, 1970s, 1980s to figure out the basis of real property. And it used to be we could go up to courthouses, we could go up to appraiser's office, we could go up to treasurer's offices and look for those. But in the last couple of months, I've had 2 separate phone calls with county appraiser's office, and they have destroyed their valuation records that were all paper. So anything that was paper is gone. And so all those records from the 80s and 90s that were paper in those 2 treasurers and appraisers offices are now gone, and we just can't get that information back. So had there been appraisals at that time, we would have been able to have some better tax consequences for some of our clients. And that's why it's really important. The other major creditor that I want to talk about is estate recovery or Medicaid. So if someone has been on Medicaid, and the beneficiaries or the trustee or the executor is probably going to get a phishing letter. What that phishing letter is, it's from the estate recovery, and it says, we want you to tell us everything this person had at their death. And that way Medicaid can try to try to collect those resources and try to get paid back. Now, there is no legal obligation to fill out that letter and send it back. And we have this conversation with our clients a lot. The second thing is not utilizing beneficiaries' specific situations and unique situations to reduce estate recovery. So I was working on a case a couple of years ago, and the mother had been on Medicaid, and estate recovery had sent the phishing letter, and then estate recovery had sent us another letter saying, hey, we want mom's house. Well, mom had left her house to her 2 children who were both supplemental needs persons. What that means is that they were receiving Medicaid themselves. They were on some governmental programs. And under the current laws of Kansas, if you leave your resources to a person who is a supplemental needs person or on Medicaid or disabled or on one of those programs, estate recovery and Medicaid cannot take that portion of your resources that are going to that special needs individual. And think about it. If the parent was on Medicaid and we took that money and we paid it into the state, guess what? The state's just going to pay it straight back out to those beneficiaries in as resources. So the idea is that we want to encourage people to provide resources to those family members that are supplemental needs persons. And so that's why we allow that. The next hidden danger of estate recovery is not looking for offsets. So one big offset that we talk about a lot is long-term care insurance. So if someone has long-term care insurance and is on Medicaid, and you can have long-term care insurance and be on Medicaid at the same time, but for every dollar that your long-term care insurance will pay, there's an opportunity to reduce Medicaid estate recovery dollar for dollar. So, a family I was working with here in the last year, they had Medicaid estate recovery, made a claim for $90,000. And yet their mother's long-term care insurance had paid $100,000 during her lifetime. And so we got the records, we sent that into estate recovery, and estate recovery said that that's an offset, and the family owed estate recovery and Medicaid $0, and $100,000 was preserved for that family. The other thing you need to know is that estate recovery, most creditors have like 6 months from the date of death, or 30 days after they've received a specific notice to raise their hand and ask to be paid. Estate recovery has 1 year from the date of someone's death in order to file a lien against real property. That's very specific. So again, estate recovery has 1 year after the date of someone's death to file a lien against real property. And so we can get through all of the other trust administration. We can get past our 6-month period. We can get past our 4 months of notice to some individuals, and yet we still need to understand that estate recovery has a year to make a claim. So, and I guess I had slides, let's see, for all of those. So when is the right time to make distributions to a family member? Well, we talked about notice, and I told you I was going to talk about notice, and that's this part. So if you look in your local newspaper, you're going to see these notices every single day or every single week, depending on how often your newspaper. And it's going to say, hey, the trust of this person is giving notice that creditors have 4 months to raise their hand or get paid. That 4 months is really important because, again, if we get through that 4 months and a creditor hasn't made a claim, hasn't raised their hand to get paid, then we know that that creditor cannot come back and try to get paid later on. Again, 30 days after a notice is sent out to the last known creditor. So if a creditor is known, there has to be notice sent directly to that creditor. But because that creditor only has 30 days to raise their hand and make a claim and say, paid. The other big time frame that we work with is the state of Kansas says that you as a trustee or an individual as a trustee, if you provide a copy of the trust, if you provide an inventory saying that all of the resources that were in that trust that were in that person's name when they deceased, if you provide an accounting showing what you spent, what income the trust had, and if you provide a distribution plan to all the beneficiaries, to those individuals, and you wait 30 days and you send a specific statute to those individuals and you wait 30 days, the trustee after that 30 days can go ahead and make distributions underneath that distribution plan without fear of any type of liability or being requested to pay or anything like that. Now, having said that, just because you can give that 30-day time frame doesn't mean you don't ask for approval. So we send out those letters. But at the same time we send out those letters, we also send a little form that all the beneficiaries can sign off saying, hey, yeah, I saw the distribution, I saw the inventory, I saw the accounting. Yeah, I've looked at the trust, everything's great. I'm going to waive that 30-day requirement. I'm going to waive all this other stuff and go ahead and make the distributions just like you have planned to make those distributions. And I think that's great. And what we find is if we do all the steps before this, right? If you've kept the beneficiaries informed, if you've made sure that you've got your notices and your timeframes and you've paid those creditors and you've done all those things, guess what? Then the beneficiaries are more likely to sign those approvals, get them back to you before that 30 days end, so you can make that distribution and speed up that process. But wait, there is still one thing that's left to do, and that's taxes. Because so for tax year 2021, which we're coming down to the end on, they aren't going to release the forms for that until 2022. And yet we want to try and get, our trust administrations that we're working on right now, we want to get them ended by the end of this year, or, barely into the beginning of next year, so that we don't have to file a 2022 tax return.
Hey, Adam.
Yeah.
I'm so sorry to interrupt, but we had a question come up on the previous slide. I thought it would be easier if you addressed it now.
Sure.
We just had a question if that includes life insurance proceeds. Could you address that?
If what includes life insurance proceeds? If the time frame for making distributions?
I'm assuming so, yes. Anita, if you have a more in-depth question, the time frame for making distributions, yes.
Okay, so that really depends on a couple of things. One is, these are all resources that flow through the trust. So if there is life insurance that's made payable on death to the trust, if there's real estate like houses, if there are bank accounts that flow through the trust, then yes, that would be the time frame for making those distributions. All the resources that flow through the trust follow these timelines. Okay. There's a separate process. It's called the probate process that has its separate timelines, and it has court involvement, and you have to get a judge's order saying it's okay to do all this stuff. I don't like doing probate. Most of the clients I work with want to avoid probate. And so that's why we're not talking about probate in this specific presentation. Some of the examples come from probate because, they're public records, so I can talk about them, but also because, it kind of highlights some of the issues that can happen when you're in probate. There's a third way, though, Anita, that resources can be transferred from one person to another person at death, and that's through payable on death designations. Okay. And so if many times life insurance, if it's paid on death to the trust, it's going to follow these timeframes. The trust will make a claim on that life insurance, and then the proceeds will go into the trust bank account and then be paid out to the beneficiaries using this process. But if life insurance is made payable on death directly to an individual, so, let's say I've got life insurance on my life and I've made it payable directly to my spouse, Alyssa, none of those timeframes are going to apply, because it's just going to happen as soon as the certificate of death is presented to a life insurance company and a claim is made. But that is a great question, and I really thank you for giving me the opportunity to clarify that there are really kind of three processes. There's probate, there's trust administration, which is what we're talking about today, and there's payable on death designations. And all three of those have a little bit of different timeframes, and this is really geared towards trust administration. Okay. Hey, Emily, can you double check with Anita and make sure that I did get her question answered and that she's comfortable?
Yes, absolutely.
Okay. So going back to taxes. So with the trust administrations we're doing right now, we'll know that there's a final tax return for 2021 that's going to be due in 2022. And so we recommend leaving a little bit of reserves just in case something comes up in those last 3 or 4 months to get that tax return in. And then make the final, whatever payment it is to the accountant or to the IRS or the state of Kansas, if there are a few little taxes due, and then make the final distributions to the beneficiaries. So how do we make this happen? The first thing is we can, I would encourage you to schedule a strategy session if you're going to be a trustee or if you're going to be a fiduciator, because the longer you wait on trust administration process to get started, guess what? The longer the administration may be. And the other thing I want you to know is that you don't have to do this alone, okay? This is MM. We helped after his wife died. And he said that, I know they have done a super job at taking care of my business for me. There are none better. You guys are the best at what you do. And I appreciate everything you have done for me after we went through this process with him. So what you've discovered, number one, keep beneficiaries appropriately informed. Two, we talked about the hidden dangers of dealing with creditors, including the IRS and Medicaid. And that's sometimes going too fast, sometimes going too slow, not knowing what those timeframes are, not making sure you're giving people time to both raise their hand, but also shutting that off when it's appropriate. And then what you need to know about the right time to distribute resources when a trust administration is going through. And last, I hope you've discovered how having a trusted guide that knows that process, that knows how to create that inventory and valuation, knows how to keep beneficiaries informed, knows how to walk you through that process can be so helpful. So if you get one thing from this presentation, following the process with a trusted guide will allow a smoother transition while maintaining family relationships. So how do we make this happen? And remember, the most important thing where we started was family harmony and trying to keep the peace. So these are important components and considerations for your family so you don't pay unnecessary taxes to the government and you do everything completely, legally, efficiently, while at the same time being open and maintaining those family relationships. And I would suggest having a trusted guide, be an intermediary between family members, even in families that get along. It just makes it a whole lot easier, I think, on everybody to have another person with their eyes on what's going on. So we help families with this. We help families talk about this. The way that this works is we do a 60 to 90 minute strategy session. We do them in person, we do them by Zoom, we do them by telephone. We talk about families' resources. We talk about families' documents or whether a family doesn't have any documents. We talk about goals that people have. We talk about tax consequences. We talk about Medicaid and long-term planning consequences. And then we look at every single person's unique situation and say, okay, is trust administration, is going through this the right thing for your family? Or would it be better for you to go through probate? Or would it be better for you to do, transfer on death designations? And at the end of that, you understand, your family understands the issues, the goals, the responsibilities of being trustee. We develop a plan for your role as a trustee. We develop a plan for your trust. You're going to know what documents you need, what tools you need, and then we'll also design a blueprint to administer your trust. Or if you don't have anything put together yet, we'll design a trust for you so that your family can have the benefits of keeping people informed, knowing that creditors are worked with and dealt through, and knowing that things are done in the right way and at the right time to protect everyone. So at our meeting, you'll hopefully decide to get started. We'll develop a written plan of recommendations of what we do, guide you to administrate the trust or create the trust. We'll prepare all the necessary legal documents so everybody is informed and taken care of, and we'll work together on other tools and steps that your family want to take. So there's a family that I'm working with right now whose parents had a farm, and at their parents' death, they wanted to keep the farm going. So we put together a way that the family members can keep that farm going even after their loved one's death. And most importantly, we're going to walk you through the process from start to finish, but not just you, but really the beneficiaries and the family. And so the strategy session is really about a $450 value. That doesn't include the blueprint and the letter and knowing exactly what you need. But if you would like a free strategy session to know kind of what's going to happen or how to administer a trust, in your unique situation, we're going to give you that free today. Okay. And so there's got to be a catch, right? There is a catch. And that is, look, on someone's death, time, resources, they can be lost. Things can come up. And the other piece of that is we really have only about 7 spots available to book a free strategy session here towards the end of the year as we're getting closer. And so if you have questions, if you have concerns, if you're thinking, okay, how do I make sure that all my beneficiaries are informed? How do I make sure my family keeps the peace? Then you can give us a call, or there's going to be a survey monkey link in the follow-up email. And here, if you do sit down and talk with us, look, I'll give you a personal guarantee. You're going to know more about what trusts look like, about what they do, about what they can't do, about how your family can benefit by going through that process more than you did today. You're going to have analysis of what happens if you do nothing. So if you choose to just let the government decide, or let the state of Kansas decide, or to go it on your own and try to meet all those deadlines and timeframes, we'll talk about what might happen, like that individual in a state versus Nelson that ended up having to pay $9,000 into the court. And I can guarantee you that your time will not be wasted. So again, if you want a free strategy session, give us a call, click on the Survey Monkey link that Emily is going to send out in a follow-up email. And here's the other piece of this. So, I'll be honest, I thought that just that free strategy session, that would be enough and that would be great. But Emily said, no. Adam, we really need to tell these people not only what happens during the trust administration and how to be open and honest, but we also need to give them a chance to get our book, What You Really Need to Know for the second half of life. And I kind of looked at who's on today, and I think a lot of you have already gotten this book and read this book and see the value of this book. But for those of you who haven't, Emily was like, Adam, just for sitting here and listening to you, we need to send these folks what you really need to know for the second half of life. So you're going to get that. And then after our strategy session, you're going to get a written summary of our recommendations for your specific situation. So remember, if you would like a free strategy session, if you would like a book that explains what you need to know for the second half of life, how to preserve those family relations through the trust administration process, you can give us a call, or you can click on that Survey Monkey link in your follow-up email. So I know we already had one really good question. Oh, there we go. Really good question earlier. Excuse me. But Emily, are there other questions that have come up while I've been talking?
Yes, we do have just a few questions, although I would encourage everyone to go ahead and type your last minute ones in the chat box right now. But Adam, we had somebody ask, can we come to your office if we've already worked with a different lawyer?
Yeah, so if someone has already worked with a different lawyer, even if they've had an estate plan set up or a trust set up by someone else, we will certainly sit and talk about what that trust says, what's in that planning, and whether or not that planning still meets with your needs. So I met with a couple, in the last 6 months, and they went to another attorney, and they had done that planning a while ago, and they looked and they realized that the trust that they had and what they had got set up really it didn't take into account that her declining health. She had some health issues, and so we needed to go and we needed to make changes so that we could take into effect her declining health. And so yeah, if you've worked with someone else, we're happy to take a look and talk about that. Good question.
Perfect. We do have one more. And speaking of talking with you, could you explain more about the strategy sessions? Like, are they one-on-one or are they group settings?
Yeah, so the strategy session would be a one-on-one conversation, either be with me, Randy Klingscale, the founder of our office, or Jenny Walters. Excuse me. One of the 3 attorneys. And there would be a short worksheet that we'd ask you to fill out before you came in. That way we could use, that time to the best of its ability and maximize your time with us and our time with you to give you our recommendations. And we'll talk through, again, we'll get to know you, your unique situation. And then at the end of that, we'll have recommendations about, what a good plan would be for you going forward. And sometimes, we look at where things are at and we say, you're in a good spot. You're on the right track. Keep doing what you're doing. And those are some of the most fun conversations that we get to have. So great question, everybody.
Perfect. Well, I do not see any more additional questions coming in at the chat box at this moment, but please feel free to add those questions now as we wrap up this afternoon. So I do want to just kindly remind everyone that you will receive that follow-up email that Adam mentioned that contains the important items. It will include a recording of this session. And so we provide that to you so you can share this with your family members, your friends, your colleagues, anyone that wasn't able to join us today, or so you can just go back through and take notes on all of the really important material that Adam covered today, because it was a lot in this very short time frame. The other thing the email contains is that SurveyMonkey link that I did also go ahead and put in the chat box. And if you fill it out, it's just a very quick 2-minute survey. You can receive the completely free strategy session. And since there are only 7 spots, we recommend you do it sooner rather than later, as well as request that free book. So I'd like to reiterate that you can call our office at any time at the number on the screen. If you have any questions regarding the strategy session, the book, or just any other questions, we're always very happy to chat with you. I would also like to invite you to stay up to date on our upcoming events on our website as well. We do have one more session next Tuesday, December 14th at 10 a.m. and 3 p.m. in the afternoon. And that is entitled How to Pay for Long-Term Care with Mr. Randy Clinkscales. He's going to go over some exclusive information on the resources and ways that we can help people navigate and overcome the overwhelming and rising costs of long-term care. So that's a very popular workshop that, if that applies to you in any sense of the word, that you probably should join us. So I'm going to do one last call for questions here before we close, and I do not see any that come up. So with that, I would like to thank everyone for your attendance today, for taking the time to join us, and thank you for presenting such excellent information, Adam. Thanks, everyone.
Thanks.